Thank you very much for joining us. This is the Freeths Redundancies and Restructuring, an informative and practical guide webinar. For those of you who haven't had the pleasure of joining one of our webinars before, this is the third in a series of webinars that we've been doing since the lockdown started. We've covered lockdown and furlough leave, unlocking the lockdown, the employment issues around that, and now we're looking at redundancies and restructuring. Broadly speaking, those topics have been led by our clients and what our clients have been asking us to advise on, and therefore what we think is topical for you guys to hear and what's important for your businesses and organisations. At the start of the lockdown process, a lot of the advice we were giving was around furlough leave, and then issues to do with returning to work like health and safety. And unfortunately now we're seeing businesses looking at making redundancies and thinking about restructuring and how they're going to organise their businesses for the post-lockdown era. And so that's what we've decided to look at today and share our knowledge and experience of those topics with you. For those of you who don't know Freeths as a law firm, we are a national corporate law firm with 13 offices around the country. We advise employers about a whole variety of HR and employment law issues. I'm delighted to say that I'm joined this morning by two other members of the Sheffield employment law team, Elizabeth Ferguson and Toby Porchon. Do you want to give us a wave, guys? There we are. They are managing associates in our team in Sheffield, and together with myself, Tom Draper, and Lee Williams, we are the Sheffield employment law team for Freeths. So just a few housekeeping rules around the way that this Zoom webinar will work. Hopefully you can drag our beautiful faces up to the top of the screen so that you can see the slides. There is also a question and answer function at the top there. So we will leave time at the end for answering your questions. So if there's anything that we're talking about and discussing this morning that you want to ask us questions about, the Q&A box is the right place to put your questions today. For those of you who have been on our previous two webinars, we've used the chat function before, but I'd like you this time to use the Q&A function, and we will go to your questions at the end, and we will answer them one by one using the Q&A function. So don't wait until the question part of the talk. Type your question into the Q&A box, and we will come to answer it at the end. We would love to hear from all of you, but unfortunately, there are, I can see 42 people signed up to this webinar. So unfortunately, we're not going to be able to discuss all the issues with you in the way that we would normally love to do. The Q&A function is the right way of doing that for webinar purposes, but obviously we are free to be contacted by you, and our contact details are at the end of the slides if you want to get in touch with any of us to ask any questions following the webinar. There will also be a feedback questionnaire that will be circulated following the webinar together with the slides, and we really do value your opinion, particularly about future topics, what's affecting your business, your organisation, so that we can tailor our future webinars to ensure that they maintain their relevance and importance to you. We're aiming to finish today at 11:30, and we've got a lot to get through, so I'm going to stop talking and hand over now to Lil, who is going to take you through the first part of our talk. Before that, I'm just going to go through the agenda quickly. Lil is going to talk to you about recent developments around employment law and COVID-19. I'm then going to go through redundancy consultation. Toby's going to talk to you about collective consultation, including changing terms and conditions, and then look a bit at when and how to use settlement agreements. So I'm going to hand over to Lil now to talk to you about the next part of the webinar.
Thanks, Tom. Hello, everyone. So the webinar today will primarily focus on implementing redundancies and restructures, but I just wanted to briefly update you on the most recent changes to employment law in light of COVID-19, just part of our current seminar series, just to make sure that you're all aware of the changes that have just come in. So firstly, as we all know, around 3 weeks ago, employees were encouraged to return to work if they can't work from home. Some of you who are eagle-eyed might have spotted that I'm in an office environment at the moment. It's my first proper day back in the office. So people are definitely coming back in dribs and drabs. So the announcement by Boris Johnson encouraging people to go back to the workplace if they can't work from home was followed up, slightly delayed, by guidance from the government as to what employers should put in place to allow their employees to return to work on a sector-specific basis. The advice for each sector had just been published when we had our last seminar. So I just want to give you a quick recap on it. The advice focuses on 5 separate points. So firstly, the clear message is still your employees should work from home if they can. If you are having employees come back into the office, then you need to, or whatever your working environment is, you need to make sure that you're carrying out a COVID-19 risk assessment. If you've got 50 or more employees, that should be published online, though there is a clear steer from the guidance that even if you have less employees than that, it is still best practice to publish it, and importantly, making sure that you're communicating that risk assessment with your team. Maintaining social distancing wherever possible within the workplace, so having systems and practices in place, whether it's moving chairs further apart, separating tables out, perhaps a policy of 1 in, 1 out in a shared kitchen. You need to assess what the particular risks are within your workplace in relation to maintaining social distancing. And again, communicating that to your employees so they're aware of what they should be doing if and when they do return to work. Managing transmission risk where people cannot maintain social distancing. So there are some workplaces where it's simply not workable in practice. And again, there's helpful guidance from the government, for instance, having people as opposed to working face-to-face, working side-by-side or back-to-back, appropriate PPE that you should be providing to them, etc. And overarching continuing obligation to reinforce cleaning processes. So again, having signs up, not only in relation to individual employees, personal hygiene, and providing hand sanitizer, etc., but also in relation to what you as an employer are doing to maintain a clean environment, wiping down kitchens, etc. So the guidance is comprehensive and it's user-friendly, and obviously it's been out for a little while now, so I don't propose to go into it in more detail, other than to note that it should be kept very much in the forefront of your minds when returning your employees to the workplace. By doing so, you'll ensure that you're keeping on top of your health and safety obligations, but also it will give you a good defence if you do receive any health and safety complaints, or hopefully not, but claims later down the line on that basis. And also, probably more relevant to most of you, it will give you a good basis to encourage your workers back to the workplace if this is in the best interests of your business. So in particular, if you're dealing with employees who are worried about it, anxious about it, that's very widespread at the moment. If you can show them in practice what steps you've put in place to comply with the government guidance, you're in a much better position in terms of putting a little bit more pressure on getting your employees back to work. Again, if that's what works for your business and it's compliant with the guidance. Just moving on to the furlough scheme, the ever-changing furlough scheme. So last Friday, the Chancellor, I'm sure you all heard, announced reforms to the coronavirus job retention scheme. A big red flashing warning sign about what I'm about to say. And we've got headlines from the Chancellor, but we're still waiting on the detailed guidance and the Treasury direction. So hopefully that will fill in a number of the gaps, which are definitely there, and answer some of the outstanding questions. But the main points of the reform scheme going forward will be, we now have it confirmed that will run until the end of October, which that was assumed to be the case, but that's now been confirmed. But importantly, it's going to close to new entrants on the 30th of June, and that's something that we weren't aware of. So that means that employers will only be able to furlough employees after the 30th of June who have completed a full 3-week furlough period before that date. So if you work for an organisation where you're still considering whether to place some new entrants onto the furlough scheme, the date for your diary is the 10th of June, because if they've not been placed on furlough by the 10th of June, you're not going to be able to access the furlough scheme for that individual. From the 1st of July, employees will be able to work part-time whilst in furlough scheme, and that's something that I know a lot of employers have been lobbying the government to introduce that form of flexibility. If an employer wishes for an employee to work part-time, they will be responsible for paying the wages for the hours worked, as you would assume, but they will be permitted to recover the relevant percentage under the scheme for the hours not worked. Again, we're waiting on the detailed guidance, but the assumption at the moment is that you are likely to be able to pick and choose in terms of the percentage worked versus not worked, and that you could have a very high percentage of work, 80-90%, and still recover the remaining 10 to 20% into the scheme. But again, we're waiting for that confirmation of the detail. From August, the level of government, from the 1st of July, you got part-time, and then from August, the level of government reimbursement under the scheme will start to gradually be reduced. So from the 1st of August, employees will have to pay employee national insurance and pension contributions, which are obviously currently covered by the scheme up to the 80% salary cap. From the 1st of September, the government contribution to salary will reduce from 80% of salary to 70%. So that will mean that you can claim up to a maximum of £2,190 of your employee's salary. Employers will then be required to pay the top up of 10%, plus obviously more if that has been separately agreed with your employees. And then from the 1st of October, the government contribution to salary will reduce again from 70% down to 60%. And that will mean that you can claim up to a maximum of £1,875, leaving employers to pay the top up of 20%, or again, more if separately agreed with the employees. So apologies, there are lots of figures in there, but it's just having a clear structure so that you're aware what costs you will and won't be able to recover during the remaining 5 months of the scheme, which will then close altogether at the end of October. What that means is it will close in terms of reimbursement from the government. You will have the option, if contractually agreed with the employees, of keeping them on furlough at a reduced rate of pay, but you won't be able to recover any of those costs from the government from the end of October. And then just a couple of other brief changes, just to make sure you're all up to speed. Statutory sick pay, SSP. So, as I'm sure you all know, the government brought in various amendments to the statutory sick pay scheme in light of coronavirus. Toby gave us a detailed breakdown of it last time, but just by way of summary or reminder, from the 13th of March, an employee became entitled SSP from day 1 of their absence, as opposed to day 4 under the normal rules, if one of the following applies. So they have coronavirus symptoms, they're self-isolating because someone they live with has symptoms, or they have a letter from the NHS or a GP telling them to shield to stay home for 12 weeks. The new change that has just come in is that following the introduction of the track and trace system, employees will now also be entitled to SSP if they're self-isolating because they've been notified by the NHS or a public health authority that they've come into contact with someone with coronavirus. So, we all assume that that should be the case because they would be in a comparable situation to those who are already covered by the coronavirus SSP scheme, but it's good to have it clarified. Also, just by way of reminder, if you are an employer with less than 250 employees, on the 28th of February, you can reclaim up to 2 weeks of SSP if one of the special coronavirus categories applies. And then just finally, in this kind of quick update section, holidays. We've had lots of queries in relation to dealing with holidays for employees who are furloughed or simply can't take them because of the coronavirus crisis. And again, we covered this off in the last seminar, but the government brought in regulations allowing employees to carry over up to 4 weeks holiday for up to 2 years, where it's not been reasonably practical for them to take it as a result of the effects of the current crisis. There was a slight residual question mark about whether employers could require employees to take holiday whilst on furlough. I mean, the widespread view was that they could, But again, until it's been confirmed by the government, it was more a legal debate. This has now been confirmed, so it's crystal clear now that as long as employers are given the appropriate amount of notice and are dealing with it in a reasonable manner, and that notice should be at least twice the notice for the amount of holiday to be taken, then you can require your employees to take holiday whilst on furlough. So that was just the catch-up section at the start. So moving on to the main bulk of the talk, which is obviously redundancies and restructures. I mean, it is something that unfortunately a lot of organisations are having to look at now. It's never the most palatable of topics, but it's just a reality in the current crisis. But there are a few very important points that you need to bear in mind if you are starting out on the process of looking to see whether redundancy is appropriate for your organisation. So if you are considering looking to reduce the numbers within your workforce, be it as part of a wider restructure or just simply as a cost-saving measure, given the impact of the crisis on your organisation, the first question to ask, and it should always be the first question, is it a genuine redundancy situation that you're facing? If you're looking to dismiss an employee and they have 2 years or more service, you have to have a fair reason for doing so. And redundancy can be a fair reason, but only if you follow a fair process, which Tom and Toby are going to separately take you through, but also if it is a genuine redundancy. And there is a lot of confusion about what that actually means in practice. But the Employment Rights Act, which is the kind of overarching piece of legislation that covers this area, is quite clear that an employee is dismissed by reason of redundancy only if one of a very discrete number of categories apply. So firstly, your organisation has to cease to carry on the business in which the employee was employed. So either the business becomes insolvent or part of that business is closed, you're no longer operating it. Or the employer ceases to carry on that business in the place where the employee was employed. So are you looking at the closure of a site or perhaps one of your branches, which is no longer operating as it should? Or finally, the needs of your organisation for employees to carry out work of a particular kind have ceased or diminished. So, for instance, your company has experienced a reduction in client or customer demand, and you simply don't have enough work coming in for your current staffing levels. If one of these categories doesn't apply, it's not going to be a redundancy situation. That doesn't mean that you couldn't have some other substantially fair reason for looking to let some of your staff go. So, for instance, you could still be looking to restructure your business to make it better, more competitive, or leaner and more financially fit going forward. But it's not going to be redundancy if your entire organisation business remains operating, you're not looking to close any of your sites, and you've not experienced any reduction in the work that you've got for your team. If the answer is yes, and one of those categories do apply, then you do have a potential redundancy situation. The second point to consider is the cost for your business in looking to make redundancies. Is it the right approach to be taking? And the key question here will be, or one of the key questions will be, will you be looking to offer just a statutory redundancy payment, or do your employees have any contractual redundancy rights? Now, contractual redundancy policies have slightly fallen out of favour, and to be honest, I don't come across them that often other than quite unionised environments, but they are still out there. So in particular, perhaps if you have any employees who've been TUPE'd across into your organisation, you need to do your due diligence and just make sure that there aren't any contractual entitlements to a higher level of payout if they are ultimately made redundant. Even if you don't, even if they don't have any contractual redundancy pay rights, you might decide to pay in excess of the statutory amounts that you're required to. But obviously this choice is taken away from you if there is a contractual redundancy policy in place, and that needs to be factored into the cost benefit analysis that you undertake when assessing whether redundancies are the right decision for the business. In addition, and I spoke about this briefly during our last webinar, you should be looking at whether there are alternatives to redundancy which make more sense for your business, at least as an interim measure, both from a financial and employee engagement perspective. The answer might be no, but you need to again assess that before going down the redundancy process. So what alternatives could you look at? Well, we now know that the furlough scheme is to be extended, at least in part, up to the end of October. So the option remains of keeping your employees furloughed for the next 4 to 5 months, and then perhaps taking a more firm view later down the line about your organisation's financial position and staffing level requirements. There's also the option of looking to retain your employees but asking them to agree to a reduction in their wages or working hours to financially assist the company. So again, I spoke about the process for doing that in our last webinar, but many businesses are finding, certainly from our clients, are finding that quite widespread organisations are going out to their employees, asking them to accept a reduction in pay, and actually getting a pretty good uptake when the question is put to them, because people would prefer to take a pay cut rather than face the risk of redundancy, especially with the current uncertainties in the economy. So it might not be something that your organisation's ever had to do or considered before, but it's something that you should be potentially looking at prior to deciding that redundancy is definitely the way forwards. You could also potentially consider asking or putting out the option of your employees agreeing a period of unpaid leave. You know, lots of people are struggling at the moment with childcare, caring responsibilities, perhaps they're living with someone who's shielding, and they might be willing to agree to an unpaid sabbatical or parental leave. It may be more attractive to your employees than it would in normal circumstances. And then also there is the option of considering some temporary laying off of staff if you've got the contractual right to do so, or applying statutory short-term working. Just a warning note on that, and again, I briefly touched on it in the last webinar, but if you do go down the statutory layoff route, this can still trigger a redundancy situation if it continues for longer than 4 weeks. It is just meant to be a temporary measure, and it is a bit of a complex process to put in place, so understandably it's slightly gone out of favour with a lot of employers. It's important for businesses to give due consideration to the alternatives prior to embarking on a redundancy process, both to assess whether it's the right commercial fit for your company, but also because during the consultation process, which Tom and Toby will take you through, whether or not on an individual or collective level, you will almost certainly have to explain in response to questions why any such alternatives weren't workable in practice, or didn't provide the cost savings that your business needed. So it's good to have gone through that prior to starting the consultation so that you have responses to those questions, and to explain why it was reasonable to still consider placing employees at risk of redundancy. So just finally, before I hand over to Tom, what are the risks of getting it wrong? Well, from an employee engagement point of view, if it's a process is not handled very well, there's likely to be more damage to your relationship with your retained employees than if it's a process which is more sensitively handled. And then purely from a cost financial point of view, if your employees have 2 years or more service and you don't follow a fair redundancy process, they can bring an unfair dismissal claim. The compensation cap for that is a basic award, which is calculated the same way as a redundancy statutory award, statutory payment, plus a compensation award, and the cap of that is less of 1 year's pay, and currently £88,519. So clearly that can be expensive, and also just in terms of the management time of fighting those awards, it's not ideal for a business. And if you are required to collectively consult and you get that wrong, then you could also potentially be facing protective awards for your employees. There's no minimum service required to bring a protective award, so it's open to anyone to do it who hasn't been properly collectively consulted with. And if successful, the payout for that can be up to 90 days gross pay. So potentially unfair dismissal awards, protective awards, and as I said, from an employee engagement point of view, it can be quite damaging. So clearly it can be costly to get the redundancy process wrong, which is why Tom and Toby are going to walk you through how it should be done in practice. Tom? Tom, you need to unmute.
Thank you. Great. Thank you, Lil. That was really good. I'll go through looking at redundancies in practice then. who should be put at risk, first of all. And I think that, in essence, this is the most important part of any redundancy process. It's the planning stage. So you've got to work out what you're trying to achieve at an early level, at an early point in the process. Because if you get this part wrong, then everything that happens afterwards will be wrong as well, and you'll get challenges from employees. And as Lil said, there are issues with potential claims as well. So I think the first question you need to ask yourselves is this a redundancy situation or is it a restructure situation? So I'll give you a quick example about this. I had a client that asked me about a redundancy process not so long ago. And they said, well, we've got 3 departments and we want to lose 2 employees from each department, making 6 redundancies in total. But we talked through, and actually the business didn't want to have 3 separate departments. Really, ideally, they wanted to have a hybrid department where employees would do a bit of the work of all 3 departments. And so what we decided to do, instead of doing 3 separate pools for redundancy, we would do we would put everybody at risk of redundancy, and we would then create 9 new roles that were the hybrid roles. So it still ended in a redundancy process, but it was a restructure, because what the business got is not just the cost saving of having made 6 people redundant, but also the benefit of having the remaining 9 people doing the job that the business wanted them to do. And so it's really important to work out at the start, yes, you might be trying to cut costs, but is there another way that you can do it that will also benefit your business in the form of a restructure? So I kind of think of it as if you're using a bit of a strange analogy, if you're looking at a Lego castle and you've got one castle, can you take the castle apart and then build 3 different houses? And you're restructuring your business in that way. And I think a lot of businesses are using the COVID-19 crisis to think about things like that, and how to set up their business going forward when employees are coming back off furlough, and what the best way of doing that is. And so actually, whilst it's never pleasant making redundancies, it can be used as a good way of setting up your business and your organisation going forward. So when you're doing the planning part of the process, it's also really important to document your thinking, because if you're challenged by your employees or potentially by an employment judge later on down the line, it's a good idea to document your thinking at the start of the process so that you've got something to refer back to. As Lil said, you need 2 main things to make a redundancy fair. You need to have a genuine redundancy situation, and you need to have a fair procedure. So out of all the potentially fair reasons, I think redundancy is actually the easiest one to justify, because a tribunal is not going to substitute their own view for the approach that they think that you should have taken as an employer. There's what employment lawyers term a range of reasonable responses that an employer can adopt in a redundancy situation, and that can be quite a broad range. And so unless the approach that the employer took is patently unreasonable, an employment tribunal is not going to interfere with your thinking. So there's quite a lot of flexibility here, and as long as you're within that range of reasonable responses, then a redundancy process should be fair. So looking at a fair procedure, then breaking it down, 3 main things need to be in place to have a fair redundancy procedure. You need to warn and consult your employees. If you're selecting employees for redundancy from a pool, you need to adopt a fair selection process, and you need to consider alternatives to redundancy as well, which Lil touched on. So if you tick all those three boxes, then your process will be fair. And you've got to remember that the role is redundant and not the individual. So when you're doing your restructure, if you're getting rid of all those roles and creating new roles, then actually you're not making those employees redundant at the point that you're doing the restructure. It's only at the point that you're not finding an alternative for those employees that you're actually making them redundant themselves, not their role. So, putting together an appropriate pool, and we're not talking about anything to do with swimming or indeed snooker. These are pools for redundancy. So they are groups of employees from which an employer will select redundant employees. When you're thinking about what an appropriate pool is, if you've got a trade union, you need to get the union involved in discussing and hopefully agreeing what the correct pool for redundancy should be. There's a wide amount of flexibility here, and the range of reasonable responses applies. And as long as an employer has genuinely applied some thought to what the best pool for selection is going to be, then the employment tribunal is not going to interfere with that decision-making process. And often, where employees are in different departments doing very similar work, there could be a whole variety of different pools for selection of redundancy that would all be fair. And so there is no prescribed route about how to approach this situation, and it will obviously depend on the specific facts of what you're trying to achieve in your business. Generally speaking, employers want narrow pools because they want to restrict the uncertainty around the redundancy process as much as possible, whereas employees generally want wide pools because a wider pool means less chance of the employee being selected for redundancy. So when you're talking about what your particular pool is going to look like, the first question you need to ask yourself is, what type of work is ceasing or diminishing? The next question is the extent to which there are employees doing similar types of work. So once you've identified what area is ceasing or diminishing, you then need to look at the extent to which employees are doing similar types of work, the extent to which those jobs are interchangeable. And once you've asked yourself those three questions, you should be able to identify a pool of people for redundancy. It can be a little harder to do with low-skilled jobs where a lot of the time people's jobs are interchangeable. And there, that might lead itself to a wider pool. But if you've got specific people doing roles that are unique within your organization and no one else could do that role, even with a little bit of training, that individual may be in a pool of one. And so you wouldn't then need to go on to introduce a scoring criteria because you've identified a unique role that can be made redundant. You also might want to think about the location of your employees, because it can be tempting to divide your workforce into different branches or premises. But if employees have worked across two branches in the past, or particularly if there's a mobility clause in their employment contract that allows you to move your employee from one site to another, it might be necessary to think a little bit wider than just the geographical location, if you have, for example, salespeople working at 2 or 3 locations that are quite close together, it might be appropriate to pool the salespeople across all the locations and not make it specific to one location. So once you've identified your pool for redundancy, you've then got to look at devising a scoring criteria and attaching weighting to that scoring criteria. Where possible, scoring criteria should be objective and measurable. So things like performance, ability, attendance, disciplinary record, they're all things that you can actually measure rather than them being involving an element of subjective judgment by a manager. So they're always going to be fairer as criteria. And if your business values one of those particular criteria more highly than another, then you can attach weighting to that criteria to make it more important. It's not always possible just to use objective criteria, though. Some roles lend themselves to objective key performance indicators much more readily than other roles. And so in some situations, there may be the need to have a bit of subjectivity around the scoring of employees who are in a pool for redundancy. If you've got a subjective element to it, it's really important to apply that scoring criteria fairly. And part of that might be getting 2 managers to do the scoring for the employees in a pool and taking an average of the 2. That will make employees feel like the situation has been dealt with fairly, and it will also make an employment tribunal judge think that you have applied the scoring process fairly as well. Examples of subjective criteria are things like attitude, flexibility, enthusiasm, which can't be accurately measured. They're all going to be subjective opinions of people, and so they're best steered away from, if at all possible. So once you've devised your selection criteria, you've got to think about discrimination issues. So 2 criteria that can be potentially discriminatory are length of service and attendance. So taking length of service, first of all, in the past, last in, first out, LIFO, has applied in redundancy contexts, and that was an accepted way of deciding who should be made redundant. But that is inherently discriminatory against younger workers who are less likely to have the length of service not to be selected for redundancy. And so when I'm advising clients about putting together redundancy selection criteria, I try and avoid using length of service because it is inherently discriminatory on the grounds of age, and therefore you would be in a position of having to justify that as a proportionate means of achieving a legitimate aim if it was ever challenged. And that's not to say it's impossible to justify using length of service, but if it, particularly if it's the deciding factor, it can leave you vulnerable to challenges and claims of age discrimination. So if there are other ways of putting together a scoring criteria that doesn't involve length of service, then that would be better. The second potentially discriminatory criteria is absence and attendance. Obviously, it's nice because you can measure it and it's objective, but you've got to remember, if you're using absence to not to count disability-related absence and not to count pregnancy-related absence, because if you make someone redundant on the basis of their attendance record as part of a scoring matrix and their attendance has been affected by a disability, then again, you're in the position as an employer of having to justify that, and that could be quite tricky. So go through the records you've got for people's absences and attendances if you're going to use that as part of a scoring matrix. Work out whether any of it is disability related, and if it is, don't use it. It's also worth, and this is a practical example from a case I had a number of years ago, it's also worth making sure that their absence records are accurate, because I was for a claimant about 5 years ago, and I worked out that the absence records that they had used weren't the claimant's absence records, and she'd been made redundant on the basis of someone else's absence. And so it's important that you're using accurate figures to measure absence, and that actually it may be worth, if it's possible, to go back and look at sick notes showing absence, just to make sure that you're using accurate documentation when you're making these decisions. So there are your discrimination issues. There are also issues around discrimination in terms of how you practically contact employees who are off sick, for example, if they're off sick with a disability long term, or if they're on maternity leave as well. You've got to think about practically how you're going to get in touch with those people. And there are issues around furlough as well in terms of getting people to meetings. And I think the tribunal will view much more flexibly the idea of holding meetings in a way other than face-to-face in the current circumstances. So, voluntary redundancies. Once you've got your pool for redundancy, you've got your selection criteria, you've done your selection process, it might be worth thinking about voluntary redundancies. Now, you've got to think about this carefully, because if there are particular individuals in your organisation that are important to you, you don't want to see leave, then if they were to volunteer for redundancy, it might cause you an issue. In that situation, it's a good idea to make it clear to employees before you ask for volunteers for redundancy that the employer retains the right to refuse a request, so that you're not in a position of seeing one of your employees who's particularly important departing in that way. And also think about how it's going to have a knock-on effect to the rest of the consultation process. If you've got a pool of 5 employees, say, and one of them volunteers for redundancy, and then you say, no, actually, we don't want to accept your request for voluntary redundancy, and you put them back into that pool, how that's then going to appear when the scoring process is done in respect of the other employees. It might give the appearance that a decision has been made before the start of the process about who they want to keep and who you want to make redundant. So that brings me on to the final point on this slide, which is be transparent. Talk to your employees. You're not doing anything wrong by running a redundancy exercise. It's allowed under the law, and there's therefore no reason why you shouldn't be transparent with your employees. Talk to them about what you're trying to achieve, talk to them about why you're trying to achieve it. And the more that you do that, the better position you'll be in if it comes to justifying any challenge that comes your way from the employees or as part of an employment tribunal claim afterwards. So practical checklist. Once you've done your planning, and I said the planning was the most important part of it, once you've got your rationale for redundancies, you've worked out whether you need a restructure or whether you are just looking to make redundancies in a particular team, then the next thing to do, once you've devised your pool for redundancies, you've got your scoring criteria in place, you've asked for your volunteers, the next thing to do is place your employees at risk of redundancy. So it's a good idea to hold a meeting with them, talk to them about the kind of things that I've just mentioned, explain to them what to expect as part of the rest of the consultation process, and provide them with adequate information about why the redundancy is necessary and what the process is going to involve. Consultation must be genuine, so it's got to be a two-way process. So you've got to take on board what your employees are saying, you've got to take away questions and go back with answers, you've got to explain to employees why the alternatives that they're proposing to redundancy might work, why they won't work in your view, and overall you've got to make it clear to employees and to a subsequent tribunal that a decision hadn't been made at the start. And let's be frank, lots of employers work backwards and they do all of this the wrong way round. They work out who they want to make redundant and then they work the process backwards to make it look like they hadn't made that decision at the start. And I'd really encourage you to not do that and work out what you need for your business and then work it through a consultation process that produces a genuine result at the end, and not something that has got the cart before the horse in terms of deciding who you want to make redundant and making the process fit around that. So adopting a fair selection process, as I said, use the objective criteria and apply the selection fairly. And once you've gone through that process, you've provisionally selected employees for redundancy, you've got to consider whether there's suitable alternative employment, not just at your company, but any associated company as well. Remember, what you consider is suitable alternative employment for a potentially redundant employee might be different to what they think is suitable alternative employment. Until you offer an employee a role, you don't know whether or not they would have accepted it or not. So offer employees roles at more junior grades, on lower salaries, in different positions, because they might be willing to accept it. Or if they're going to bring a claim afterwards, they will certainly say, oh, well, I would have definitely looked at that role if it had been offered to me, but you didn't offer it to me, and therefore the redundancy is unfair. So there's a really good reason for offering employees any suitable, any vacancy at your business and letting them decide whether or not they think it's suitable, because then you will definitely put a big tick in the box of considering suitable alternative employment. And also consider it really early on as well, because the worst thing is to get halfway through a process and realise that a potentially suitable vacancy has just been filled. So if there is a potential suitable vacancy, talk to your at-risk employees at a really early stage about whether or not they want to take that vacancy up as an alternative to being made redundant. People's choices at the moment are going to be affected by the pandemic and the job market at the moment, and you might find employees going for roles that you wouldn't have thought were suitable, but ultimately it's got to be their choice. Individual consultation is still required even if you consult collectively. Yeah, I mean, Toby's going to talk to you about collective consultation in a minute, but consulting collectively doesn't get you out of consulting individually. You will still need to go through individual consultation, even in a collective consultation scenario. So, just running you through the practical elements of a redundancy process then. Once you've placed your employees at risk, You then do, and you've got your pools for for selection. You apply your selection criteria. Employees are then provisionally selected for redundancy and should be invited to consultation meeting to talk about their scores, to talk about any alternatives the employee might have to being made redundant, and be prepared to change the scores. This is a really important point about showing that the process is a genuine consultation. It's really good as an employer if you can listen to an employee who thinks that they should have been scored differently and alter their scores. And with that in mind, it's a good idea to, when you're telling employees who are provisionally safe, that is just provisional, because if you're changing scores following consultation with another employee, you may well be placing them at risk of redundancy again. So once you've done your scoring, you've got your provisionally safe, you're provisionally selected, you've consulted with your provisionally selected, and then you move on to answering any of their questions. And if and when their questions are answered, you're in a position to have a final redundancy consultation meeting. And at that meeting, an employee has the right to be accompanied. It's a good idea to give them the right to be accompanied by a trade union representative or a work colleague at all the consultation meetings, but there is a legal requirement to have the opportunity to be accompanied by a trade union representative or a colleague at the final dismissal meeting. And if nothing changes at the final dismissal meeting, the employee doesn't raise another challenge or another question, or tell you that they want that they've got another alternative to a redundancy, you can proceed to confirm the redundancy in writing following the final consultation meeting. At that point, you give them notice of redundancy. So you've then got to decide whether you pay them in lieu of notice or whether they work their notice period. At that meeting, they should also, or once you made that decision to make them redundant, you should give them the option of an appeal. And as with a disciplinary process, the appeal should be to a more senior manager who hasn't been involved in the consultation process up until that point, if that's possible within your organisation. And you should, at the final meeting, explain the redundancy payment that the employee is entitled to. And as long as you've looked at alternatives to redundancy and you've offered them the suitable alternative employment and they have turned it down, if there is any, then you can proceed to make the employee redundant. You may need to build in more meetings into this process, depending on the employee and what they are asking and what they are suggesting. So it's okay at the start of the process to have provisional dates in the diary for at-risk meetings, selection process, first consultation meeting, and final consultation meeting, but you may need to add in other meetings if the employee is coming up with a lot of questions and a lot of challenge and a lot of criticism along the way, just so that you show a tribunal that you've treated the employees being made redundant fairly and have adopted a fair process. So that brings me to the end of my section of the talk. I'm just going to finish off by giving you 4 top tips for redundancy. The first one is spend time preparing. Ask yourself at the start, what is the goal? What is the rationale? What am I trying to achieve here? Are there any alternatives to redundancy? What pools should be used? What scoring criteria should be used? And really think long and hard about what the process is going to look like before you embark on it. That's my first top tip. Second top tip, be prepared to listen and explain to employees what's going on. Be transparent and communicate well with them. Number 3, document the process from start to finish. As lawyers, we like to see that all the consultation meetings have proper notes of them. The worst thing is to getting a claim and there isn't any record of anything that's happened, because that allows the employee to fill in the gaps and it allows for disputes of fact to arise that can go against you at an employment tribunal. So document the process throughout. And finally, take legal advice at the start. If you think it's going to be a tricky redundancy process, if you think that there are characters in the redundancy pool that are going to push back on this, I appreciate there are commercial realities, especially now, that might mean that you want to do a redundancy process quickly. You might want to save on legal fees, but really it's a good idea to take legal advice at the start of the process, because we can tell you where the risks lie. That's really our role as lawyers in a redundancy situation, just to explain the legal risks and mitigate those risks where possible, and balance that against the commercial reality of the situation and wanting to get the redundancies done. So they're my 4 top tips. And now I'm going to hand over to Toby, who has the pleasure of taking you through collective consultation. Take it away.
Thank you very much, Tom. So we're going to start off this part of the webinar with a poll. So we've got this fancy new software that allows us to ask you guys a question and to responses. So fingers crossed it's going to come up on the screen in a minute. But we're just going to ask you all just to vote on this. So have you conducted a collective consultation before? So there's 20 seconds to answer this. Now, I was trying to work out as Tom was speaking how to fill 20 seconds. So I actually only worked for Freeths for a year. So I've actually never heard Tom give his analogy about Lego before. So A, I like that. B, I'm having that. And C, I'm going to try and work that into, oh, nice. I'm going to try, I'm going to try and work a Lego analogy into the rest of my talk. Now, I've banged on over the top of that. Okay. So over half of the people have conducted a collective consultation before. That is interesting. I mean, collective consultations, as far as I've experienced them, they're tricky, they're interesting, and they're really practical. Collective consultation, it is as it sounds here, right? What you're doing is you've got an obligation to consult with a group of employees, as well as then going on to have the obligation to consult individually with each of their employees as well. So for the purposes of this talk, collective consultation means where you are proposing to dismiss as redundant more than 20 employees at a single establishment over a period of 90 days or less. You have to go through consultation to consult with representatives, and you also have to notify the Secretary of State as well. For these purposes, collective consultation itself has some pretty significant obligations that come along with it, and also has some pretty odd definitions too. So redundancy in the collective consultation is where you're going to be dismissing someone or terminating their contract or employment for a reason that doesn't relate to their conduct or their performance. So normally that is, as Lil described before, a downturn in work, a restructuring where that team's going to work. But what that does is it also catches where you might be ending a group of people's employment contracts and then re-engaging them on new terms, to changing terms and conditions of employment. Now, it all covered under a piece of trade union legislation called the Trade Union and Labour Relations Consolidation Act 1992, TULRCA. So what TULRCA says is that if you are proposing to dismiss as redundant more than 20 at a single establishment, then you have to collectively consult. A single establishment is clarified by a case that involved Woolworths, when Woolworths went into liquidation. As a side point, I miss Woolworths, but because I do quite a lot of collective consultations, I get to talk about them quite a lot, which is always nice. So what happened with Woolworths is Woolworths as a group decided to close and liquidate. Now, what the collective consultation regs say is if you're doing it as more than 20 in a single establishment, then you have to collectively consult. And Woolworths said, well, actually, each of our individual stores is its own establishment. So if that store has less than 20 employees, then we don't have to do collective consultation at that store. And that was found to be correct. So individual establishments themselves, if they've got less than 20 employees, there's no obligation to collectively consult, even if as a whole group, the wider group company is going through a big load of redundancies as well. So what clarifies as an establishment is a matter of law. So normally it's a discrete entity. It's got a degree of permanence, stability, it has its own workforce, technical measures that go along with it. It doesn't necessarily have to be legally, economically, administratively, or technologically autonomous. It doesn't have to have its own separate management. and it doesn't necessarily have to be geographically removed from other parts of the business. But if it's distinct and you can say, well, actually, that site in and of itself had less than 20, then you can avoid collective consultation. Now, what collective consultation does is it creates this period of time whereby you are formally required by law to consult with elected representatives of your workforce. If you're making more than 20, but less than 100 redundancies in any 90-day rolling period, you have to consult for at least 30 days. If it's over 100, then it's at least 45 days, and it's 90 days in Northern Ireland, if any of you have any of your workforces there. So what that means is the consultation has to continue for that length of time. You don't have to necessarily consult for the entirety of it. Technically, what can happen is you kick off consultation, day 2, everyone agrees, no issues, but you can't do anything, you can't enact any redundancies until the end of that 30-day period. So technically, that could happen that quickly. In practice, that does not happen. What happens is you generally have a bunch of meetings as you're going through, and it tends to last for at very least the 30 days, if it's over 20, normally a little bit longer, just as you're trying to wind things down. As Lil said before, failure to collectively consult is a 90-day pay award per affected employee, regardless of length of service. The unique aspect of that claim is that it starts at 90 days. So it's 90 days pay, and the employer argues down why it wasn't a serious breach. Most of the aspects of employment law, it's what is your loss, and then the employee is trying to argue it up. This one goes, bam, 90 days pay per affected employee. If that's a couple of hundred, there's not many businesses who could cope with a couple of hundred people bringing claims for 90 days pay, just simply because you failed to collectively consult. You also have to notify the Secretary of State. It's BEIS now. An acronym escapes me, but something to do with business innovation and skills. A business enterprise innovation and skills, I think. It's a dead straightforward form. It's called HR1. You literally email it to the Secretary of State. It's got some pretty factual information on there about the groups of redundancies and what you're going through. If you don't take that step, A, the time limit never starts running. So the 30 days or 45 days starts from the date that you notify the Secretary of State and the date you appoint and notify representatives. If you don't take that step, it's criminal liability. Criminal liability for the directors of the business. It is only a fine, so it's not like they're going to end up at Her Majesty's pleasure, but there is no point in not doing it. It's really straightforward. And what they then do once they are notified of that form, they pass the information to the local job centre. So when I've been running them for clients in the past, what you tend to see is we fill that form in, notify Secretary of State, I then, or whoever notifies them, gets contacted by the local job centre, and they provide can provide on-site face-to-face support for employees. That is a great employee relations tool, because not only is it kind of being done in any event, you can then use that to your benefit. Say to those employees, well, look, what we've then done is we've been in contact with the local job centre. They're going to send a job advisor over to come and help you guys with some outplacement support. Here's how it all runs through. And it can be a really useful way of doing it. So what collective consultation is in its essence, so sorry, this is just the next slide, it is getting a group opinion. So it's having representatives, feedback from a group of employees, common questions, concerns, what are the next steps going to be, all those things that individuals would be asking you, be asking that as a group. Now, there are two main groups that you can use to consult with. You have to consult with elected representatives. If you send the information that I'm about to describe below directly to employees as individuals, you will fall foul of the collective consultation obligation. The collective consultation obligation is to send this information directly to either elected representatives or trade union officials. It is a trade union piece of legislation. It's heavily weighted in the favour of sending this to trade unions. Now, if you've got a recognised trade union body, you have to collectively consult with them. If you have a recognition agreement with a trade union, that's fine. You've probably negotiated that out anyway. The problem I find with those, so my background, I used to be a trade union solicitor and then moved over to advise businesses for the last sort of 5-6 years or so. The problem what I found with negotiating with trade unions is you have a bargaining unit. So the bargaining unit, the trade unions, how they want to cast it is generally every employee. But what most of the times I'll be saying is, well, it's employees in a certain sector. Now, it does not matter if that employee is a member of that trade union. They will be caught by the bargaining unit that the trade union can negotiate for. The problem with that is that when that employee goes to that trade union and says, I've got some questions, the union member, in my experience, generally says, sorry, mate, you're not a member of the trade union, so I can't speak to you. So you end up with this sort of dichotomy. You've got the groups of people they're negotiating on behalf of, and then they're actually excluding some people. So where you've got a trade union, you have to formally consult with them as well. But generally what I find is if you have a group who aren't represented by the union, and you can accurately identify those, I tend to appoint what's called a works council, so a group of employees who can also be appointed for that task. You tend to find that you then have those two groups together. You normally see them together. I had one recently where the trade union refused to sit down with the works council, so I had to have two sets of meetings. That's not uncommon, but it doesn't happen all the time. Generally, what you want to do is have more consultation than less, really. Get as much information as you can from those individuals at the start to understand what issues you're going to face. So if you don't have any trade unions, you normally elect representatives. That technically under the law requires you to run an election process. The ones that I've been involved in, normally what you'd simply do is say, we want representatives. Anyone who wants to be a representative can be a representative, as long as it doesn't get too silly. So I had one recently that was 150 staff, and we ended up with, we ended up with about 15, 16 reps. That's fine, having that group of people all feeding that back in. Equally, I've had ones where it's been, again, a couple of hundred employees, and they've appointed one or two representatives. Those things are fine. The more, I always think kind of the more the merrier. The more information you can get from those people, the better. But you tend to find that the people who want to be representatives are the people who are quite vociferous in your workforce. That's not necessarily bad, because what you want for them is to try and gather as much information from the outside employees as possible. So when they come and meet with you for a collective consultation meeting, where they're feeding back in that feedback from the individuals, you can filter it down. So loads of questions to start off with normally, that then filters down, answer them all, and then you can move on to individualized consultation once that's completed. Now, consultation, the timescales for consultation kick off when you send the information to the elected representatives. So you fill out form HR1, send that to Secretary of State. You have to notify on that form that you've also provided a copy of the form that you've just sent to the Secretary of State to the elected representatives. Now, what normally happens in my experience is, if you don't have a trade union, so you can't front it up with them and get their approval to move ahead with it to start off with, what you end up doing is sending this letter, which sets out the reasons for the proposed dismissals, the number and description of the employees who you might dismiss as redundant, the total number of employees who are proposed to go, the method of selecting them, how you're going to go about carrying out the termination, proposals for calculating redundancy payments, and then information about agency workers. What you tend to end up doing is sending that statutory information to employees in kind of a summarised form. So you dial it down a little bit. And then you say you need to elect representatives to be able to consult about this. Once they've elected representatives, you then need to send that information again to the representatives, and that sending to the reps is what is required by the consultation regulations. So it's those little nuances that can be quite tricky, and it's getting that right at the very start that can be fairly time consuming. As Tom said, the best way to progress any type of consultation is to get your plan in place first. A planning session, working out probably what the likely questions are going to be about that, getting the information out to everyone, being transparent, electing representatives, and then you're into collective consultation. Now, I think that as a piece of legislation, the collective consultation rules themselves are fairly onerous, but actually the result from them is really good. Because if you didn't have collective consultation and I wanted to consult with hundreds of staff members about a redundancy, I'm going to have the exact same meeting hundreds of times, and I'm going to get the exact same question asked of me hundreds and hundreds of times. And I think what you tend to find with these collective groups is I'll end up with hundreds of questions, and they're all sort of similar. They're normally like, what are alternative vacancies? But some people might say, what are the alternative vacancies? What are the other jobs available? Why haven't other opportunities been given to me? And they're the same question, just asked in many, many different ways. So you can tend to find that once you've gone through the consultation starting off, you get these little questions, they funnel in, you answer them with the representatives, and then every that bit of information just starts feeding back to the employees, and they start getting maybe not on board with the proposals, but they start feeling more comfortable. Also, if you have a collective group, people, if they're going through a consultation, can be fairly confrontational. They're more likely to be a bit confrontational with their representative, but they're on the same team. So you end up getting a point where their ire is directed towards the representative. They'll then get a question that can be quite confrontational, but then dampens down a little bit. So by the time they're meeting with either an elected person who's coming on behalf of the business or the business themselves, that question's, it's softened in its approach. Because if people said to you what they wanted to say to you at the very start, that might not be very complimentary. But once it's gone through a rep and it's come to a meeting, you end up with a codified question that you can then answer. Now, the obligation with collective consultation is that it is done with a view to reaching an agreement. So it's got to be genuine. It's got to be ways and means of avoiding those redundancies. But equally, that can be quite useful. If we say, well, actually, we can't maintain this part of the business anymore, we just don't see it as being profitable. You go through collective consultation, you might find that you get a fair amount of decent ideas. I have seen that in the past where other opportunities have come in. People have talked about the different skills and the requirements, the ways to make efficiencies in the business. A business has then taken those on, and we avoid the redundancy taking place. That's the aim of that aspect of it. It doesn't always happen, but it's worthwhile going through that process. A, you're legally obliged to, and B, it can become quite a practical aspect to it. Also, you can use it as an employee engagement tool. So there's very few times when you would actually get all of your employees together in a big group and have them put proposals about how to make the business more profitable, how to make the business more efficient. So having that as a starting point and saying, well, this is what we want to achieve, how can we all get there? That can be very useful. And it also allows you to moot the idea of an overall reduction in pay. So a lot of redundancies come in and businesses say, we don't want to carry on with that aspect of the business. If you go through and you say, well, we don't want to reduce pay for every employee because we just don't think it'll work, we don't think people will agree to it, you've closed your mind to that part of it. Whereas in a collective group, you could say, well, what are the views from everybody? Would everyone want to take a 10% pay cut for a limited period of time? And that'll help us prevent these redundancies or prevent them from being so wide scale. That's decent because then it's a proposal that's been made, it's been well thought through, and you've ticked that box of, well, what did I consider to avoid the redundancies? I put it out to everyone. There's a resounding no, so we didn't move ahead with it. And it's decent. And you don't have to accept that proposal, but you do have to consider it. As Tom said, collective consultation does not remove or overstep the need for individual consultation. You have to do both. Collective consultation normally comes to, I wouldn't say an abrupt end, but it normally sort of fizzles out. More, and they keep back and forward, lots of different meetings, and then we get to a kind of final frequently asked questions document. Everything's been answered, and some people have specific individualized problems that they would need to go through. Maybe part of the selection criterion mistreats them because they're disabled and they didn't want to tell their representative that. We wouldn't know that until we individually consult. The consultation regulations, they don't, no, shockingly, they don't cover the fact that there is a global pandemic on. So the obligation to consult just simply says that. There is no, as far as I can see in the regulation, there is no formal obligation to face-to-face consult with someone. You don't have to sit across the room from them. There is still the obligation to consult with them and hear their views. So probably going to be done virtually. It's going to be done by telephone call. Some trade unions that I've seen at the moment are insisting on it being face-to-face, and therefore are insisting on the consultation meetings taking place after, a quote from the one union I had the other day, after the global pandemic. I mean, what can we do? You can't have that, so you have no idea when that's going to take place. So we went back and said, no, it's reasonable to hold it via, it was Microsoft Teams or via Zoom or any other conferencing service as well. As long as you can do it remotely and you've got the technology in place to be able to do it, you should be using it like that. Now, just running on then to the next slide, which is about changing terms and conditions. I noted I am banging on a bit, so I will cover through this fairly swiftly. If you're changing terms and conditions, technically what you're doing is you are ceasing one contract and you are engaging an employee on another contract. For everyone who's an employer on the call, if you give someone a pay rise, generally they don't mind. Generally, they don't want you to have to go through a collective consultation to discuss pay for the next 30 days, even though you are ceasing them on one contract and engaging them on another. Generally, this is happening where there is a detriment to them, either losing some sort of benefit, or there's an overall structural change about how their terms and conditions work. So if you're doing this because you want to cut pay for either an extended period or in essence for forever, or you want to change the way that a remuneration system works, like a guaranteed bonus scheme, you would have to collectively consult. Now, there's two ways to approach that. You can just seek agreement to start off with, send it out to everyone and just say, this is what we want to do. Everyone, do you all agree? If everyone agrees, then we'll put it in place. Now, if everyone agreed, happy days, you can put it in place. And that's the same system as if you're giving someone a pay rise, right? If everyone doesn't agree, what you could do is say, well, okay, we're going to hive off the people who do agree into one group. So we've got the agreed people, and then we've got the second lot of people. And we look at that and say, well, is there now an obligation to collectively consult with that group? Are there more than 20 that we might be dismissing and then re-engaging on a new contract? If there are, we have to collectively consult with that group. Now, that's the two ways to approach it. Or you could just simply start collective consultation with everyone, see who agrees, and then kick them out of the consultation at that point. That's my preference. You mainly for a couple of reasons. A, it starts the 30 days running or 45 days running at the start when you kick off that consultation. So you're not going agreement stage, couple of weeks to questions, we haven't got an agreement, and now we have to collectively consult. So we've got two sets of consultations. Equally, it doesn't produce then two sets of groups of people. The group who have agreed, who you might have given a signing bonus to of a couple £100, and then you've got who hasn't agreed, who's going through the consultation process for a minimum 30-day period. And you've got these two separate groups within your organisation. I think that's quite unsatisfactory. So I always say, well, look, seek agreement where we can, we collectively consult, so we get those questions from people. But it might well be that the people who we're collectively consulting with have actually got some really valid points about the changes that are being made. And so the people who've now agreed might end up with different contracts than the people who haven't agreed and then gone through collective consultation. And that's not, I personally don't think that's right. I think that the group aspect of collective consultation should be done. Everyone's involved in it. Everyone runs through it. The proposal is made to everybody. And then we say, well, actually, the worst outcome that the business can receive here is that we terminate everyone's contracts and then immediately re-engage on the new one. But we don't want to do that. What we want to do is get everyone's agreement about that change first and foremost, deal with any issues that might arise from it, and then put that contract in place at the end of the minimum period. As I say, it can be with a collective consultation obligation that you start off, everyone just agrees, and then it can't put in place until the end of a 30-day period. To be honest with you, whilst it sounds like quite a long time, actually, when you're doing the administration part of hundreds of people, changing those contracts, properly changing the contract, put them all in place to take effect from the end of a 30-day period can be quite an administrative undertaking in any event. So I always think, kick it off, get it going to start off with. The weird thing with the change in terms and conditions is that technically you're making redundancies, but it's not a redundancy. Now, when you send the letter out to people saying, this is what we're proposing to do, in it, you have to send them the HR1 form, and the HR1 form, unhelpfully, has redundancy stamped all over the top of it. So you end up having to have a letter that says, we want to change terms and conditions, we're not making you redundant, we want to have these proposals in place, and know that form says redundancy, but don't worry about that redundancy aspect of it. That just needs careful wording to get that over to people to make sure they're not going to get too upset about potentially being dismissed. And then very finally for me, I'm just going to cover off very briefly settlement agreements. So settlement agreements, they're a confidential agreement between an employee and an employer that settles out an employee's potential claims. Normally, this is in exchange for a sum of money. Generally it's notice pay, holiday pay, redundancy or an equivalent, and then some sort of sweetener. They are by far the safest way to exit an employee from the business. In essence, you're buying their rights to bring a claim against you. They waive any and all claims they might have. Now, the real benefit to employees here is A, they get an agreed exit, but also because it's a contract that you're reaching with your employee, you can agree pretty much anything within the realms of good taste. So you could agree a reference, a strict form of reference that you would provide for that employee. You could agree to not make derogatory comments. You could not slag each other off in the open market. Now, those are things that a tribunal cannot functionally award. So an employee might be coming down and say, well, actually, the money is not great, but I know that I'm going to have to go onto a new job role. And if I get no reference at all, or a reference that is very defamatory, that's going to hamper my ongoing business prospects. So it can be quite an attractive option. I had one a little while ago with there's a chap who spat in his boss's face. And so they went through a settlement agreement. I know Tom Winters, yeah, it was horrible. And so he agreed to go on the back of a reference. And just went through a settlement agreement there. No cash, no money, no nothing. Everything was waived. Just had that reference on the back of it. That's not a common scenario. Thankfully, not a common scenario, but that can be something that the business could look at doing as well. Generally, we look at what's the alternative. So the alternative here is the carrot and stick argument of, are we going to go through a redundancy process? Are we going to go through a poor performance process, a real common one for settlement agreements? Are we going to go through a misconduct process where we end up potentially ultimately dismissing that person, or do we offer them a settlement agreement now? The settlement agreement in that respect is normally used to avoid potential litigation risk of that employee bringing a claim against us for us getting the process wrong, or just simply then bringing a completely unmeritorious claim. They're just that difficult employee, they're going to sue us, so we decide that actually we don't want that distraction from trading and ongoing potential risk, we're going to settle out with them. That's perfectly adequate. Or we know we've actually physically definitely got a risk of this. So we want to settle that claim that's become about because something's happened in the business. We didn't particularly agree with it, but it's definitely a claim that we're potentially looking at defending. Or we're just doing it out of the goodness of our hearts. Not common that we get involved in those ones, but you can just have a time when they're just simply paying someone because they've got a long service. You can hold now what's called a protected conversation with an employee. So that is, in essence, you discussing with them the termination of their employment on an agreed settlement agreement. They're great because they allow you cover for an employee who could go completely out of the blue for them. They think everything's going fine, but I can just say, look, we just don't think we can continue with your employment, or potentially we don't think we can continue with your employment. Here's an offer for you to go. And they would not be able to use the contents of that conversation against us in an employment tribunal. And the confidentiality in that aspect extends to the very fact that the conversation even took place, as well as the contents of the conversation. So it is a powerful tool to use. The employee has to take legal advice on the contents. You can't agree a settlement agreement without that. Normally, the employer pays a sum of money towards their legal fees, £250, £350, something like that. It smooths it over. You don't have to take that step. In my experience, if you don't take that step, you're less likely to get the deal. They have to go and take legal advice for it to be binding, so you may as well pay just to smooth those wheels over. The key issue in the settlement agreements is you can pay part of it tax-free. Notice pay, holiday pay, bonus, commission, all those are taxable benefits. You can pay a sum of up to £30,000 tax-free through a settlement agreement or through maybe not a settlement agreement, as long as it's not something that is a consideration for doing something else. If it's simply a loss of office, compensatory payment, and it is tax-free. What we encourage everyone not to do is try and be tricky and include other potential taxable elements in that tax-free sum, because HMRC will likely investigate it and say, well, actually, we think the whole that's taxable, and then we're embroiled in a tax dispute on that. So that's a bit of a whistle-stop tour of settlement agreements. But we've got some questions that have come through. So that's actually all I want to talk about. So we have got a few Q&As as well. I'll pass that back over to Tom. Oh, I didn't put Lego into it. Right, yeah. Next time, I'm definitely getting a Lego analogy in there.
You'll have to get a Lego analogy into one of your answers to these questions, David. Yeah. I'm thinking now. So we've got a few questions. Thank you, Toby. That was really good. So the first one is from Debbie, and she asked me, length of service on selection criteria. How do you feel about using cost of redundancy, which is also related to length of service as a cost, will be critical? So I presume that's where you're looking at making a particularly expensive employee redundant and can you use their salary almost against them as part of a selection process? That's not a good way of looking at it. I mean, as you said, Debbie, in your question, salary is often pinned to length of service, in that if you've been somewhere longer, you're likely to earn more. And so there is still a potential for age discrimination there. But really, your selection criteria should focus on what skills and experience you need for your employees going forward, rather than what cost you need to get rid of. So I would steer away from that as part of a selection process. And maybe it's better to look at it in terms of which employees are we choosing to retain, rather than which employees are we choosing to dismiss. Because if you look at it that way, then building on what I said earlier in the talk, you're going to have a better business going forward if you've got the best employees, rather than trying to get rid of the most costly. So I hope that's answered your question, Debbie. I'm not sure if there's a function on this Q&A to get back to me to confirm whether that's the case or not. The next question, please can you just explain the 3 things to consider for pooling employees again? Yes, so you have to look at, firstly, what type of work is ceasing or diminishing. That's the key. What type of work is ceasing or diminishing? And then you've got to look at whether employees' jobs are interchangeable. So if a certain type of work is ceasing or diminishing, there might be 2 different job roles that do a bit of that work. So don't be led just by job title, be led by what the employee actually does on a day-to-day basis. And I think if you've got the question, could one employee do that role, another employee's role, with a little bit of training, then you've got your answer as to whether or not those jobs are interchangeable. And if they are interchangeable, then it would be a good idea to pool those roles together. So the three points again: what type of work is ceasing or diminishing, the extent to which employees do similar work, and thirdly, whether or not those roles are interchangeable. Again, just some reassurance, you've got some broad scope here as an employer to decide your selection pool. So as long as it's not completely off the wall, then you've got a good chance of showing a tribunal that's within that range of reasonable responses. And also the tribunal will judge your approach based on the size and administrative resources of your business. So a small employer, again, has more flexibility, not just in terms of pooling, but in terms of the process as a whole, because the tribunal will take into account the size and administrative resources of your business. So yeah, thank you for that question. I hope that's answered it. There might be a way of explaining whether or not that was the case. The next question is Zobi, and the question is, can you use LIFO, so that's last in, first out, as a deciding factor after using a scoring criteria where 2 people have scored the same? Again, Toby, I think I'll take this one just because it's my part of the talk. I'd advise against that, because as a tie-breaking thing, length of service is then going to be the determining factor as to why someone was made redundant. And therefore, you're in a position where you are much more likely to be discriminating against someone because of their age. And so if you've got length of service as part of a selection matrix, that actually might be better than using it as a deciding factor, because it's less likely that that's going to be the reason why someone was made redundant. If you're using it as a deciding factor, then it will be the reason why they've been made redundant. And if they're younger and they've got less service, then that will be age discrimination. And then you're in a position of having to justify it. And as I said earlier, it's not impossible to justify. In fact, the leading case involved Rolls-Royce, and the Court of Appeal backed using length of service in that particular situation as one of a number of factors in a redundancy selection pool. But that isn't always going to be the case. And I'd rather not be in the position of having to justify a discriminatory dismissal. I'd rather not use it at all and come up with some different scoring criteria that doesn't put you as an employer in that position. So yeah, thanks Toby for that question. Just moving on to the next one. Debbie has asked, notice of redundancy, is there guidance on extending it to extend contractual notice to the end of furlough, e.g. to October, to assist an employee? Okay, so this is where you're presumably making furloughed employees redundant. Toby, do you want to take that one?
Yeah, that's fine in my opinion. Yeah, I mean, I've had a couple of redundancy processes that we started off a couple of weeks ago. When we come down to the end of it, my ongoing advice has been you can't really make redundancies during the period where furlough is running. So I've been pegging the end date for most employees' employment to be the end of July, to the end of the current scheme. So yeah, where the government's paying you 80% and there's no sort of contributions from an employer. So yeah, absolutely fine. Generally, you want to make sure that you have specifically agreed that with the employee. I have had quite a few where we've sort of given them the two options. You're going to go A, you can go now on your current notice, 100% pay up until 3 weeks, whatever it is, or we can continue to employ you until the end of the current furlough scheme, the 31st of July. You'll be paid 80% for the period up until X date, and then your last weeks will be your notice. That gives the employee a bit of flexibility. If they've got a new job role they want to go to straight away, then they can. If not, then they've got the benefit of using the job retention scheme until the current variation of it ends. And that's entirely appropriate as far as I'm concerned. The scheme's there to keep people in employment. If you want to keep them on to the end of October, that's okay. I think it's a little bit speculative right now because you don't know what the terms of those. You don't really finally know what the terms of those. The new scheme's going to be after sort of the end of July or August time. So I'd be a bit cautious about doing that. But you could say to them, it runs until the 31st of July, and then at that point we'll agree something else with you, as long as it was certain in the terms that you've given to them.
Yeah, I mean, the only other thing I'd add to that is the employee will continue to accrue holiday during any period of furlough leave. So that's going to be a cost that you're going to have to bear at the point that their notice period eventually ends. And that could be quite substantial if they're on furlough to the end of October. And remember, it's a tapered scheme, so you're going to get less and less benefit from the furlough scheme over that period between the end of July and October. So it's going to become financially less beneficial to do that, particularly if you're replicating that across a number of employees. So I think in summary, there's no legal principle that will stop you doing that as long as you agree it with the employee, but just think about the financial consequences. Right, thank you for that question, Debbie. Next one is from an anonymous attendee. Please go over your top tips for redundancy again, Tom. Okay, so first of all, spend time preparing. Think the process through and make sure that you understand what you're trying to achieve and how you're going to achieve it. Secondly, be transparent and communicate. Be prepared to listen and explain as part of the consultation process. document the process from start to finish, including your thinking at the start and why you're thinking it. And finally, take legal advice at the start to make sure you get everything in place that you need to be in place to allow you to do the procedure fairly. So spend time preparing, be prepared to listen and explain, document the process, take legal advice. Great, thank you. Anonymous attendee, whilst furloughed, can we set up an employee rep group with which to consult, worried about that being classed as working? Toby?
So, yeah, you can do that, yeah. The scheme itself excludes employee representative issues, so you can do that. And it's a really good idea to get that going as well.
Great, thanks Toby. And then that is it for Q&A. We did have a few questions around furlough and redundancy that came in before the seminar, which were in essence around the calculation of notice pay for employees who are furloughed at the moment. And it's a bit tricky, but in essence, the answer is you can't get benefit of the furlough scheme if you're paying in lieu of notice. That's the first thing to say. But if you're making an employee redundant or dismissing them for any other reason, and they're working their notice whilst on furlough leave, then if you're giving them the statutory minimum notice or less than a week more than the statutory minimum notice, then the furlough pay will apply, and you can pay them if they're at 80% of their normal salary. You can pay them at 80% of their normal salary for the rest of the notice period. If they're receiving, sorry, no, that's wrong. You can pay. You have to then pay them at 100%. So if they're getting statutory notice, which is 1 week for every year of service up to a maximum of 12, they're getting statutory notice, then they have a right to 100% of pay. If they're getting contractual notice, and the contractual notice is more than a week more than the statutory notice, then you can pay them the furlough pay. So if they're paid 80%, then you can continue to pay them their 80% for the rest of their notice period. Okay. So I hope that's clear on that. It's quite complicated in terms of the way that notice pay is calculated, especially when furlough is involved. But in essence, if they're getting their statutory notice, then there's a requirement to pay them in full. If they're getting contractual notice, which is more than a week more than the statutory notice, then you can pay them the furlough pay.
I think that it's so subject to dispute. You know, it's one of those. You can explain that to an employee, and they'll go to a solicitor, who will then write to you and tell you that you're wrong. You know, so there's a further question that just come in as well. Would you recommend topping up notice pay if they're currently furloughed? I mean, the clients that I've been speaking to have been topping it up. You know, I think if you were doing a much larger program and you could get everyone's agreement, or your furlough agreement said, and if we give you notice, we'll give you 80% of your pay, then you might be okay. But I think if it's the case of, you know, topping up to an additional 20% to avoid those larger claims coming in, but also to avoid there being a potential breach of contract, you know, avoiding any restrictive covenants or confidentiality clauses that you've got over senior employees, my recommendation, depending on the circumstances, would be to top it up. But Thomas might be different. We haven't always agreed on them, which is good, which is healthy.
Yeah, I mean, the thing with furlough leave is it's so new, and there isn't any case law on it, that you might well get a divergence of opinion about that. Yeah. I think that if you're making a lot of employees redundant, then 20% of salary for a lengthy notice period might be a good way of trying to save costs. So it'd be worth taking legal advice about whether or not you can do that, because it might be quite a large sum of money depending on how many employees are being made redundant. There was one final question that we got before the seminar, which was around the calculation of redundancy pay whilst on furlough leave, and whether you should use the furlough pay or normal pay to calculate redundancies. Now, obviously, that's only going to be an issue if employees are earning less than the statutory cap on a week's pay, which is currently £538 per week. So in most situations, it's not going to make a difference, and you're just going to be calculating redundancy pay based on that cap. You can't claim your redundancy pay back through the furlough scheme. And there are really tricky and complex ways of calculating redundancy pay to do with working out when the relevant date is, which is the date, normally the date when an employee is given notice of redundancy, and the calculation date, which is the end of the statutory notice period, or when that would have been. And so I think in terms of calculating notice pay, again, I think it's worth taking legal advice, because it will be different for every different employee that you're making redundant, whether or not they're on furlough or not. So come and talk to us separately. I'll roll on to the final slide, which has got all our details on, and you've been sent these slides before the webinar. So we're all there for you to get in touch with if you need to. I've had apologies from Lil while the webinar's been going on. She's had to dip out early, but she did want me to pass something on before she left, which is the date for our next webinar. Stick this in your diaries. It's going to be at 10 o'clock on the 23rd of June, and it's going to be on protecting your business in the age of COVID-19. So talking about restrictive covenants, confidentiality, looking at issues around furlough leave and employees working at home, and how you can protect your confidential information in that scenario. And so there will be an invite coming round soon to everyone who's on the mailing list. If you want to join the mailing list, let us know, and you'll receive an invite for that webinar, 23rd of June, 10 o'clock. Toby, do you want to add anything?
No, that's great. We've had a very final question that's come in there that has said, how long would a whole consultation process take in time? So the minimum is 30 days if it's over 20. Generally, consultation process from planning to completion, 6 to 8 weeks. I probably budget for a bit more, depending on how many people you're talking about and what changes you're making. Can be fairly short, no less than 30 days. But yeah, 6 to 8 weeks, something around that.
Yeah, I mean, that's 30 days for collective consultation. If you're doing small scale redundancies of less than 20 employees, the minimum you can get away with is probably 2 weeks. But to be comfortable, you should be budgeting for between 2 and 4 weeks, I think, depending on the number of meetings.
You want people to feel heard as well. That's the main part of it. If you just have a consultation meeting on Wednesday and dismiss them on Friday, it feels quite quick, and that can lead people towards jumping to conclusions that you've just already made that decision prior to speaking to them. So if you set it out, that's a solid timescale.
Great. Thank you all for joining us, and we'll see you soon.
Great. Thanks, everybody.